Now the next, I am not going to say anything about the next one because you'll say that I am prejudiced in my praise of the next speaker because it happens that we are compatriots.
I want to introduce John because I think since when he arrived in the 5th edition of Shipping and Law, we had so many great people here, starting from Professor Francesco Berlingeri, who attended the first 3 years of the conference. But with the arrival of John, you know, everything became different. And John obviously doesn't need any introduction. He was president of the Greek shipowner, European shipowners, as also Manuel was, the vice president of ICS as Ebsen. But I want to say just two things of him. He's a great shipowner and he's a great man. So thank you, John, to be here for the 2nd year, and I hope you can participate to many other additional Shipping and the Law. Thank you.
Thank you very much, ladies and gentlemen. Since we are in a church and we are all sinners, I am also a fallen man, and I have already fallen off the edge once this morning, and I must not do it again, especially since Roberto talked about princesses. We have 2 potential princesses of the European Union right to my left, so I don't want to fall off the stage again. But thank you very much for inviting me back, and thank your excellent team on behalf of all of us, please, Francesco, because they have been wonderful. And I would like to say that my presentation this year is focused on, it's in a sense a continuation of what I had to say last year, which is about the problems of decision-making and of regionalism in the European Union. But since the title of my presentation is The State of Western Shipping, I am looking not only at the European situation, but the international situation. And since the state of Western shipping is a very wide topic and a very kind of encompassing title, I shall basically concentrate on the regulatory and on trade policy matters. But what do we mean by Western shipping? As you've heard already, world shipping is currently controlled 40% in terms of gross tonnage by European interests and 42% by Asian interests. 18% therefore is the rest of the world, while Western shipping ostensibly includes also non-EU shipping, which means the US, Canada, Central and South America, and even countries that are not in the West, such as Australia and New Zealand. Significantly, most of these countries that are not in the EU are port states rather than shipping nations. So, with all due respect, it is true to say that in effect, Western shipping is European shipping. Themio yesterday, in his very encompassing and very kind of interesting and telling presentation, mentioned, which is true, that seaborne trade will always be, and so shipping will always be. The question is, who will be doing it, and in what parts of the world? It is now a truism to state that the focus of world trade and by extension shipping has gravitated to the Pacific Ocean and the Far East and has moved away from the Atlantic Ocean and the West. This means inter alia that increasingly Western ship owners register vessels under Asian registers and establish offices in maritime hubs in Asia, thus boosting these maritime clusters and the overall activities of ports in the area. So it is perhaps more correct to talk about shipping of Western provenance or belonging to Western interests rather than Western shipping. And this qualification brings to the fore the ambivalence between a shipping enterprise as an international actor in activity, which what Thomas mentioned before, and the nationalism of its regulators and their perspective. This is a problem to which I shall return. Meanwhile, talking about the state of play in shipping and about the importance of Asia, 20 out of the busiest container ports worldwide, out of the 20 busiest container ports, only 3 are located in Western Europe, 1 is in the US, and the remaining 16 are in Asia. Asia also provides the major part of seafarers to the West, with Philippines being the major labor supplying country in the world. Asia provides the major shipbuilding yards in the world, with China, South Korea, and Japan competing between them for their respective rank and for the orders from Western shipowners. Western shipyards, having completely lost their preeminence, which they enjoyed until the mid-70s, are now limited to a handful of shipyards which build specialized vessels, and especially cruise ships. Moreover, apart from the dynamic increase of the Chinese fleet, similar phenomena of fleet development occur in other Asian countries, such as Vietnam and India. Asian shipowners' associations are increasingly promoting their cooperation in policy making and in international fora. This is the case with the Asian Shipowners Forum, the ASF. In addition, claims that IMO has been too Eurocentric have probably led to the election of 2 consecutive Asians as IMO Secretary Generals, Mr. Koji Sekimizu, who has just stepped down, and Mr. Ki-Tak Lim. So what is shipping policy in the West doing in the face of the above developments? Well, I am more of a kind of skeptic than Thomas, so I say not much, or not much that is really helpful. First, as Thomas mentioned, there is the problem of unilateral or regional regulations. Then the problem of aspirational regulations. These problems are interlinked, and a major part of the counterproductive over-regulation in shipping. In my presentation to this audience last year, I had the opportunity to expand on these issues. I highlighted the endemic tendency in the northwestern hemisphere plus Australia for the adoption of regional or unilateral measures, preempting or going beyond international requirements, mostly a result of aspirational agendas. In the EU in particular, aspirational regulations leave the detail of prospective legislation for adoption by the so-called comitology procedure under non-transparent procedures. Examples are ample: the CO2 emissions and the MRV directive, the SOx directive, NOx emissions, reception facilities, ship recycling. The same phenomenon occurs in the US with its federal requirements on ballast water management systems and the various requirements which it seems cannot be controlled of its coastal states regarding air emissions and other matters. Aspirational regulations usually require equipment and technology not yet available or proven, ostensibly in order to promote future innovation. But their requirements cannot be complied with, and they should therefore not be introduced until this technology is available and proven. Regulations should be globally implemented, as has been mentioned, practical, cost-effective, and especially based on sound environmental, technical, and socio-economic evaluation. Hence, aspirational regulations are not positive. The West is shooting itself in the foot, so to speak, by continuing to adopt them on a unilateral or regional basis. The precautionary principle is often cited as applying to the environmental legislation that the EU and the lawmakers in the EU consider, and they consider potential risk as being equally important as demonstrated risk. This is one reason, it seems, for the adoption of these aspirational legislation. Though the EU precautionary principle has its merits, no doubt, a more balanced approach should make more sense, and above all, proper consultation with stakeholders. The foregoing leads to the issue I would like to highlight in this presentation, and which has been mentioned: consensus building for better regulation. In general, consensus building has become more difficult to achieve in our times, and Professor Roberto referred to this, and so also in the context of the IMO and in the EU. This is so at intergovernmental level, but even within our own industry organizations. Consensus does not necessarily mean unanimous support for a position, but rather a position all can support more or less. The absence of a consensus approach is counterproductive for shipping, which is a global industry, requires and depends on international and long-term solutions. Adoption of a position considered proactive, as has been mentioned, may often disguise a perception that some commercial advantage may be conferred on the state or company advocating it. This is not a fortuitous approach when it comes to the industry's response to policy making and regulation. Policies and approaches should not be short-sighted or antagonistic. Rivalries among companies or states in the West, in the regulatory field, are to the detriment of its shipping industry in the long term. Moreover, it does not assist the efforts for better regulation as announced in recent initiatives in the EU and pending in the IMO, which are welcome, and it is sincerely hoped that they will lead to concrete results. In the European Union, President Juncker, among the other issues and perspectives that Thomas Redder mentioned, has initiated a better regulation initiative coupled with a so-called refit exercise, and this should entail consolidation and reduction of existing EU legislation in all fields, including maritime transport, and production of new legislation with parsimony. This means adoption of new regulation only if there is a compelling need to do so and on condition of the feasibility of the measures it proposed. I think personally that this is a response to the Euroscepticism that was demonstrated in the Euro elections last September and the new Commission which has been installed since January this year. More particularly, the key elements of this better regulation agenda are more and better consultation covering the entire life cycle of a Commission proposal. The consultation process will also relate to delegated acts and important implementing acts. Every stakeholder or citizen will also be able to express an opinion via a dedicated link to the Commission's Better Regulation website. Better regulation through better impact assessments of Commission's draft legislative proposals. Delegated acts and important implementing acts will also be subject to impact assessments. Third part of this agenda, refresh existing legislation. The better regulation agenda also aims at a continued assessment and evaluation of existing legislation so as to ensure that it stays fit for purpose. This will also include public consultation. And fourthly, an inclusive approach. The European Commission will actively seek the input from stakeholders on ways to improve EU legislation through the dedicated REFIT stakeholder platform. In the light of all this, stakeholders will be able to express their views over the entire life cycle of a policy. Roadmaps and inspection impact assessments will give stakeholders the chance to provide feedback and prompt them for relevant information from the very beginning of a new initiative. After the Commission has adopted a proposal, national parliaments will have the opportunity to provide reasoned opinions on subsidiarity. In addition, the Commission will invite citizens and stakeholders to provide feedback within 8 weeks. In order to feed these views into the legislative debate, the Commission will also collect them and present them to the European Parliament and the Council. All stakeholders will be able to provide feedback on acts setting out technical or specific elements that are needed to implement the legislation adopted. For the first time, the draft texts of delegated acts will be open to the public at large on the Commission's website for 4 weeks in parallel to the consultation of experts in the Member States. Important implementing acts which are subject to committee opinion will also be made public for 4 weeks, allowing stakeholders to submit comments before any vote by Member States in the relevant committee. The Commission will publish an indicative list online of any such acts in the pipeline so stakeholders can plan ahead. Last year, I pointed out that as a result of the entry into force of the Lisbon Treaty, decision-making in the EU had become more complicated and less transparent. Through the increasing use of the so-called trilogue process, both formal and informal, between Council, Parliament and the Commission, as well as the procedures of delegated and implementing acts. The Better Regulation initiative that I just outlined in quite at length, and its impressive parameters, will cover the whole decision-making process, including the trilogue procedures and implementing and delegated acts, with a view to rendering them more effective and transparent. So, ladies and gentlemen, all this either sounds too good to be true, or on the other hand, it may amount to very little through the introduction of what I can call consultation overkill, lost in consultation, so to speak, with anybody, whether qualified or not, allowed to be involved. Only time will tell. In the meantime, it is worth reiterating that unfortunately the European Union acts as a bloc of 28 countries at the IMO, a fact that, it has been seen, has two consequences. Firstly, it alienates other nations, including major nations like the US and China, and thus makes consensus building much more difficult. And secondly, it makes important for EXA and the EU shipping industry to try and straighten out the European Commission's proposals before they are consolidated and presented en bloc at the IMO. In this context, it is important to note that as a last resort, a blocking minority in the preparatory stages leading up to and including the EU Council meetings is now achievable if 4 member states, 4, are in opposition. A similar initiative to the EU Better Regulation is currently under preparation by the International Chamber of Shipping with regard to the IMO in order to avoid the repetition of the Ballast Water Management Convention saga. The IMO will be asked to revisit the guidelines on the organization and method of work, taking into account factors already mentioned such as compelling need, economic impact, technological availability, feasibility, etc. Turning now from the quality of regulation in the West to the content of policy as such, the West must always seek to safeguard its shipping sector's competitiveness on the global scene. Yesterday we had a very big discussion about its financing, which is also a crucial issue. We should not forget the fate of Western shipbuilding and the mistakes that led to it. It is also high time that the EU and the US proceed with more and better cooperation and on trade and shipping. Thomas Redder mentioned the TTIP agreement as a case in point, and its maritime chapter is useful and necessary to forge closer ties between the EU and the US, including the maritime sector. The TTIP agreement potentially could create the world's largest free trade zone in the West. Its geopolitical significance, therefore, should not be underestimated. Free trade could inject new life into the Atlantic Alliance and set benchmarks that other emerging powers would find hard to ignore in future trade deals. The TTIP is focused on removing non-tariff barriers, harmonizing standards, cutting red tape, and boosting safeguards for investors. If exporters do not have to adapt to 2 sets of rules but 1, there will be more trade. It is noteworthy that this month, the 11th round will take place, with maritime transport on its agenda, next week in fact. The TTIP is expected to prevent new market access restrictions in the US for EU shipping. Indeed, apart from the Jones Act, that blatant piece of protectionism in a country that is ostensibly a champion of free trade and liberal economics, there are currently the US export control laws that restrict international maritime transport services. In addition to the already existing restrictions, there are indications that the US might be considering the implementation of a general program to promote the export of LNG and shale and oil gas on US flagged ships. Such restrictive practices are not consistent with free trade and WTO principles. The CETA agreement between EU and Canada is another example going in the right direction of trade liberalization. Also, the African continent, with its proximity to Europe, should become an obvious area for further expansion of Western trade and shipping. Already there is significant intrusion of Asia into Africa and more particularly of China. Apart from the EU-ACP agreement with African, Caribbean and Pacific countries, the EU can do more in the area of bilateral trade agreements. Africa has much untapped potential and the race is on. Finally, it goes without saying that Western shipping will continue to face strong competition from third country registries and from global shipping centers in Asia and the Far East. At a time of acute unemployment ashore, in particular in the EU, shipping and its attendant maritime clusters can be a source of wealth and employment. Preservation of maritime skills, know-how in the West is an element essential to the competitiveness and sustainability of shipping, as is the prevention of the deflagging of vessels and of company relocation. So, and to conclude, ladies and gentlemen, maintaining the competitiveness of its shipping is of fundamental importance for the West for strategic, economic, commercial and employment reasons. Western policymakers must make sure that they are in a position to respond to the fierce competition from third countries and shipping centers. It bears repeating, look what happened to commercial shipbuilding in the West. Thank you.
Thank you, Yanni, with Dublin. And Mr. Lyras addressed a huge...
Mr. Lyras, it's impossible to summarize your intervention because it's already so clear, right?
On the contrary, I was going to say that it was, he tackled such a huge and immense list of items that it was very difficult to keep track of what he said. But I took note of his praise of my speech yesterday, and I thought that was very important. Never mind.
And lunch is approaching.
John defined Western shipping as comprising that of Europe, the United States, Canada, and Australia. That is a group of countries that constitute the lion's share of world shipping. However, he admitted that Asia supplies the overwhelming percentage of maritime workforce. And he had some comments to make about the unacceptable adherence to unilateral legislation versus global regulation. He addressed the issue of ballast water management and the fact that because the convention has not yet come into force and because the US Coast Guard has not yet approved any of the submitted ballast water management systems, this may end up with the industry, that is ship owners who in good faith have installed such systems, being unfairly penalized when the convention comes into force, and they find out that against some $1 to $5 million invested in installing such systems, these systems may not be found in compliance with the convention. He referred to consensus building and how important it is, explaining that they should not be construed as meaning unanimous acceptance, which of course is what IMO tries to do, to build consensus in whatever the organization adopts, which may end up with some prolongation of the time needed for a new standard to be adopted, but it is better to go that way through avoiding divisive voting. He referred to the European Union consolidation of existing legislation, and he said that only when there is compelling need to do so, new regulation should be adopted. He mentioned the inconclusive approach of the Commission, the Commission agreed to practice, and the importance of consultation. And at the end, he referred to large free trade zones in the world, and that some trade agreements recently agreed are not in conformity with World Trade Organization practices. Thank you, John. That was very revealing and very informative. Thank you very much.